This is State versus McClafferty, and each side will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes. I always have the same rules that we always go over, and that is that, don't use any children's names, and I don't think this is applicable here, but still, I'd like to go over with everybody just as a reminder. And let me know if you want to save the time. All right, and we're ready to proceed.
Thank you, Your Honor. Mr. Buchanan, on behalf of the appellant Brett McClafferty, I would ask to reserve 5 minutes of my time for rebuttal.
That's good. Thank you.
I think at some level, this case is relatively straightforward in that the court went beyond its authority and entered a nunc-pro-tunc order that changed a substantive part of the sentence, and a substantive part of the sentence that was clearly on the record and in the original entry and belonged in the original entry. Not to belabor the point that's in the brief, but Attorney Sallerson, who represented the state at the sentencing hearing and change of plea hearing, reflected repeatedly that it was to be 225 days credit for time served. And that entry was never appealed by the state or challenged by the state. And when I believe, as I said, this was not something that was contained in the record, not something that I was privy to, but based on what was going on at the time with Mr. McClafferty's other sentence, I believe the Bureau of Sentence Computation had contacted the court for a correction in a case number as it related to a Portage County case, because the entry did have an error in the case number. So I believe that essentially caused the original examination. And then the prosecutor, because of what was going on in Geauga County, had essentially taken a position that Mr. McClafferty had gone back on the deal that was the substance of this case by filing an appeal of a motion for jail time credit in Geauga County. That appeal was subsequently denied, but we believe, based on the briefing, that essentially what happened here is the state was trying to backdoor a remedy that they could not get via enforcement of a plea agreement to essentially strip these 225 days from Mr. McClafferty. So we believe that the appropriate remedy is this has to go back to the trial court for an awarding of those 225 days, or simply an order that corrects the sentences in Portage County and does not strip Mr. McClafferty of the credit. Essentially, the state could have appealed this if they had disagreed with this credit, and moreover, this is credit that they entirely authorized, put on the record themselves, and as this court decided at some length in I apologize. Not this court. I apologize, Your Honor. It was the 8th District went into this issue in some length and relied on State v. Jones for that proposition that essentially the jail time credit statute doesn't even apply to the state. The state cannot seek continuing jurisdiction to correct jail time credit, even if there was an error. But in this case, as was shown at the sentencing, there was no error. I mean, this was to the letter the exact amount of credit that the state themselves argued for at the time of sentencing.
Attorney Buchanan, question, please. So if there had been no other cases pending in any of those other counties and this was the only case, would he have been entitled to 225 days of jail time credit in this case only?
I believe so.
Okay, in this case only?
I believe so. Okay,
but not in any of those other cases?
Correct.
Okay, thank you.
Yes, and ultimately, I mean, if one side or the other, to kind of follow up on that, had raised issues of the possibility of credit or credit being calculated differently, that is something that we could have argued at the trial level and kind of established in a better means, because it does get, as this court is well aware, it can get complicated assigning credit for time served when a defendant has multiple cases. So that's why reliance on the entries is important, is because we took a look at that potentially complicated issue. Everybody agreed it was 225 days, and that was that. So I think that that is an additional reason for keeping that in place, is because these are can become complicated issues. If there's no other question, I would just reserve the balance of my time.
Okay, sounds like there's no other questions, so thank you. FLE?
Thank you, Your Honor. Good morning, and may it please the court. I'm Jacqueline Corrigan on behalf of the state of Ohio. 2 points I'd like to make right at the outset. First one is that the state is not disputing that when the parties were in front of the trial court discussing Mr. McClafferty's plea and sentencing, that when they were discussing the issue of jail time credit, the state doesn't dispute that the prosecutor agreed that Mr. McClafferty had spent 225 days in the Summit County Jail. And that, getting to Judge Schaefer's question, if this had been Mr. McClafferty's only case, then he would be entitled under the statute, under the existing law, to 225 days of jail time credit. This is not Mr. McClafferty's only case. He has had multiple cases in multiple counties. And I will make it very clear that by stating that Mr. McClafferty, excuse me, was in jail for 225 days and taking the positions that we are, the state is not in any way going back on or trying to renege on the plea agreement that was reached on that day with Mr. McClafferty. That is not the case. However, the state cannot sit back and say that the trial court's determination that Mr. McClafferty is entitled to no days of jail time credit. We are not agreeing that that's a correct statement. He actually is not entitled. We are not going to challenge whether he gets 225 days at this point because, like I said, we're not reneging on the plea agreement. The state's point in all this is that in this case, the trial court, when it issued it's actually the second nunc-pro-tunc order in this case from March 18th of 2020, that when the court issued that order, it reached a correct statutory conclusion, but in the wrong way. And it did do one thing right. It did correct the Portage County case number. That part of that order is correct. But by making a substantive rather than a ministerial or clerical or mathematical correction to the valid sentencing entry, which turns out to be the October 2019 nunc-pro-tunc, and doing so without any kind of statutory authorization, then we don't have a proper nunc-pro-tunc under the established law. The order then is a nullity, and therefore the order is also not a final appealable order. So it's the state's position that the proper remedy in this case is for this court to remand this case back to the trial court, which was in the midst of proceedings to discuss the propriety of the March 18th, 2020 order when the appeal was taken. Because there had been a hearing on this issue, there were briefings that the parties submitted, and prior to the court issuing a ruling based on those briefs, Mr. McClafferty took this appeal, and here we are. So again, it is the state's contention that the trial court did the right thing in reaching the right legal conclusion, but it did it in the wrong way, and the state is not challenging that Mr. McClafferty spent 225 days in the Summit County Jail, but the state would urge this court just to remand this case back to the trial court.
So if I can make sure I understand correctly, so the state is saying that because of the plea bargain, even though the trial court was correct in its subsequent nunc-pro-tunc entry, it agrees that it's not going to challenge the 225 days credit.
That's correct.
Okay, so would both sides be amenable to the court just, and I'm not saying, I'm speaking for myself, I'm just asking. I'm not speaking for the full panel or the court, but would you be amenable to just having the court remand this back on the basis of the nunc-pro-tunc to issue the 225 days credit?
I think that is the proper remedy, Your Honor.
How about you, Mr. Buchanan?
We would not be opposed to that, Your Honor. I mean, my client, for him, it's a practical question of when is he released from the Department of Corrections, and if it's 225 days sooner, any jurisdictional questions, it's not his concern.
Yes, the state.
I didn't mean to interrupt you. You still have time, but.
Oh, that's all right. I was just going to follow up by saying that the state would prefer that the trial court, resolve this issue, before it. Like I said, the parties had submitted briefing, the trial court had a hearing, and the trial court's resolution of this matter was cut short by the notice of appeal. So the state would ask this court to remand it back to the trial court and let the trial court resolve this. So that's the state's position. And other than that, we would rely on our briefs, and thank you very much.
Thank you. Mr. Buchanan, did you want to say anything else? You still have 5 minutes remaining.
Yes, very, very briefly. As to the timeliness of appeal, as this court is aware, the appellate deadlines are jurisdictional deadlines. And if they are not taken within that deadline, this court could be stripped of jurisdiction. So the appellant did appeal within 30 days of that entry, despite the fact that the court did order subsequent briefing. But subsequent briefing alone, as this court is aware, would not extend the deadline to have filed this appeal. Essentially, the court could have sat on the briefing indefinitely. There was no requirement for a subsequent order. So we believe we did appeal at the appropriate time. And we are opposed to the court having this remanded for an independent determination of jail time credit at this point. I think that's kind of what the state is also advocating for. And I believe that would be improper because it is, it's far too late in the process for that. And it was already decided once. I mean, criminal sentencing entries are meant to be given as much finality as possible. To allow the state to re-argue credit for time served this late in the game is contrary to statute, contrary to due process, and contrary to the existing case law from the Supreme Court. And with that, we would also rely on our briefs unless there are any further questions.
Well, I think the state is indicating, though, it's not going to be contesting the 225 days regardless. So, well, at any rate, thank you all for your presentations, and the court will take the matter under advisement. And we will issue a written opinion, as you both know, and we will also release it electronically, and you can check on our website as well as the Supreme Court website. So thank you both very much.
Thank you, Your Honor.
Have a safe day.